Good afternoon, everyone. Thank you for joining us for our monthly DVAP CLE. This month's CLE is over how to do expunctions and non-disclosures as a way to clear up criminal history. My name is Kristen Salas. I'm one of the mentoring attorneys for the Dallas Volunteer Attorney Program, or DVAP as we affectionately call it. For those of you that are not familiar with us, we are a joint program with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys that will do their civil cases from start to finish pro bono. We take a wide variety of cases ranging from family law to probate to consumer matters. And of course, we do a lot of expunction and non-disclosures. This is our only little branch into the criminal world. Expunctions and non-disclosures are actually a civil case filed in a criminal court. And the reason we do them is, as our mission is to help people improve their lives by getting housing, getting better jobs, that sort of thing. Getting your arrests off your record is going to pave the way to open doors to get said jobs, housing, that sort of thing. So we are blessed today to have two wonderful speakers. Our first speaker is Adrian Bauer. He is the managing attorney for Bauer PLLC in Dallas. His practice is split between plaintiff side litigation and consumer and commercial matters. And then also he has a heavily pro bono caseload that he does specialize in expunctions on. He has been named one of DVAP's finest. He has serves as secretary treasurer of the Dallas Young Attorneys Foundation and is the co-chair of several DAYL committees. He received his JD from St. Mary's. And we also have with us Nick Tufexis. I'm sorry, I butchered that, Nick. I'm so sorry. But he is a partner at Saputo Tufexis, and they practice criminal defense law in Dallas. They help numerous clients all over the state, ranging from Class C misdemeanors to first-degree felonies. And he has been named one of DAYL's One to Watch for February 2023, and he received his JD from SMU and is also a Navy veteran. So without further ado, I will turn it over to Adrian and Nick. And just one more note, if you have questions along the way, feel free to put them in the Q&A at the bottom, and then Aaron and Nick will get to those at the end of the presentation. So I will turn it over to Aaron and Nick. Thanks.
Thank you all for being here with us today. It's an exciting topic, these expunctions and non-disclosures. I may start with a story for y'all about why I became so passionate about doing these for DVAP clients. One of the first one of these record clearing petitions that I brought forth was done on behalf of a client who found themselves in their own apartment where they lived alone on a Friday evening, only to be startled by someone trying to break in. Turns out it was an ex-roommate who hadn't been there for months. But the ex-roommate was high out of their mind and persistent about coming inside where they no longer lived. The actual resident, frightened, informed them that if they crossed the threshold of the home, he was going to have to use, lethal defense, perhaps. It was at that point that the perpetrator called the police on the person who lived in the home. That person, the resident, was charged with terroristic threats against a household for defending his own home. The charges were ultimately dropped, but that didn't finish the story at all. the way the law is written in Texas, the arrest and or charge of a crime stays on your record unless you do something proactive to get rid of it. There are also waiting periods. For this charge, it was a 5-year waiting period for that kind of felony. And anytime they applied for a job, immediately what any employer saw was terrorism. In a post-September 11th world, that person was unemployable for the next 5 years. And that is why I take any of these cases that I can. The catastrophic impact of simply being accused of a crime that you didn't commit, or one where a court said that this isn't one where we see fit to punish the accused, just has hugely detrimental effects on a person's ability to be a functioning member of society. And so that's a bit about what we'll be talking about here today, and the ways that you can accomplish that for your clients. Switch on. So the record clearing relief that we're talking about, we mentioned a few of the things, the simple act of an arrest. Even if no charges are brought, that becomes part of your criminal record. So people who do a deep enough dive or who are savvy on the internet can type in your name and maybe see a mugshot picture of you. In terms of an indictment, that would happen with a felony charge. But even if you make it to a grand jury and they no-bill it, and the grand jury doesn't see fit to bring charges against you, the fact that the attempt was made to institute those charges and that you were probably arrested prior to that will tarnish your reputation. The information is the indictment equivalent for a misdemeanor. Even if you get acquitted at trial, the charge still remains unless you do something. I think Nick may talk about this a little bit more later. There may be ways that you could be automatically entitled to some record clearing relief, but that entitlement isn't the same as putting in the paperwork. And so that's one of the things that we'll make sure that y'all are armed with the knowledge to best represent your clients and make sure they don't get stuck in a hole they don't need to be in. Pretrial diversion programs are something that's important. It's an attractive way to minimize the harm that may come to your client from having faced charges. And sometimes there will be instances where you can handle it the wrong way. And it's real important, especially if you're doing this in private practice, to know how to plead properly. And so we'll go over some of those things. The other issue is for convictions. There are some examples where after a conviction, you might be able to get relief. Some places on the internet may tell you that's not the case. They're few and far between, but we'll go into some of those nuances. In terms of the impacts, we've talked a little bit about those with the story I told, but the inability to get work for some of these clients who are seeking this relief is very real. And the practical application of it is that these would-be clients will go apply for jobs out there, and their resume just gets thrown in the trash pile once the background check comes back. The prospective employers aren't telling these people you were rejected because of your criminal record. It's just a no, and the pattern becomes pretty apparent. There's something that these people are seeing that makes them not want to hire people with records. And so the purpose of this is these record clearing relief petitions is to make sure that that's no longer, a reason to not give these people a chance to be functional members of society.
Funny you say that though, because I've actually made this mistake when I first started. I had a pretrial diversion client, to get the expunction, but I didn't know I had to take some affirmative steps to do that. So when they asked me about it, I was like, oh yeah, it just happens. Realized real quickly that's not the case. So this is why this is important to know this stuff. So you don't look like me one day when I did that. So
call it practicing law for a reason.
Practice all day.
So there's a big distinction between an expunction and a non-disclosure. If I had the choice for any of my clients, expunction would be the route I'd want them to go. Now, if if you've got somebody who's coming to you after the conclusion of their criminal case, it's probably too late for you to steer them in the course of an expunction or non-disclosure. The way the law is written, somebody who qualifies for an expunction probably necessarily doesn't qualify for a non-disclosure, and vice versa. If you're handling their criminal matter in real time, then based on the way your client pleads and the way the case breaks out, it may steer in one direction versus the other. But with the benefits of the expunction being so much better, it's vital to know the difference, to know the procedural steps, to do what you can to get your client in the expunction realm as opposed to the non-disclosure one. So what the expunction will do will be totally obliterating all record of the arrest, the charge. An order is signed instructing all the parties who have that information to shred it, manually delete it from computer files, incinerate it, anything to get rid of it. So we've got our little Thanos snap here. It will turn the charges, arrest, mugshots into dust. The practical application of that is that you have to draft your pleadings right and your order to make sure that parties who may be in possession of that knowledge know that an order's been granted. And so that's something we'll get into a little bit more later. But you're only as good as the extent to which the information of the order has been spread. So the other benefit here of an expunction for your client is they will have the legal authority to deny that they were even arrested. The law actually says that this is legal authorization for you to deny an event that you took part in. It's pretty extraordinary. The one limitation of that may be if you're testifying under oath in a criminal case, you probably need to disclose that the expunction was sought and granted, and that will probably be the end of that inquiry. In terms of the non-disclosure, as opposed to completely obliterating all records, it really just seals it. So it keeps prying public eyes from seeing it. There are various institutions that may keep it, law enforcement, various licensing boards. I've seen it happen with nurses, doctors, things like that. And it's a sticky widget, I guess. And all the more reason if you're in the game prior to the final resolution of the charges, it's so much more beneficial to have that steered to an expunction. The other fun thing we've got down here is the civil relief, which is something that I haven't seen many other practitioners talk about, and there's actually not a ton of case law on it. But both in the Business and Commerce Code, Section 109, and the Government Code 411, and I think the Government Code 411 actually, it's mostly about non-disclosures, but it has some language in there about expunctions. But it actually makes it, I think, a criminal act for people to publish information about an expunged or non-disclosed record. On top of that, for an entity that sells criminal record information and sells removal services, for these entities out there that say, pay us $150 and we'll take your mugshot off the internet. If they are charging more than $150, they can get hit with penalties awarded to the person with the order that can be up to $500 a day for a continuing violation that's knowing, as well as attorney's fees. So it's extraordinary. If we did the math on that the other day, and it's probably $70,000+ a year for the silly company out there that insists on continuing to publish information about a charge that's been expunged or non-disclosed. And so a lot of those entities may be hiding in the Caribbean and whatnot, but it's an interesting opportunity for a cause of action for some of those people who've been down on their luck, and maybe a way for them to get back in the game a little bit.
All right. So this is my favorite meme I found on the internet. I don't know who this is. I don't think it's here based on the flags. But like it says, gave my client a life sentence, but I looked spectacular. Okay. We don't want to be those people. All right. We want to protect our clients' interests. Okay, you can look as good as you want, but you got to do right by your client. Okay, and so this meme kind of encapsulates what we're talking about here. So looking here at the plea stage. So one of the things that comes up a lot is multiple charges. So I see this a lot where, somebody picks up a charge in Dallas County, they got one in Collin County, they got one in Tarrant County. Well, if I get them deferred here in Dallas, but they still have these other charges, if I plea him here in Dallas, and then you get him deferred, he pleads out, he's got the judgment, and then I go to Tarrant and I plea him there, and I go to Collin and I plea him there. Even if it's deferred on all of them, he's pleading to charges while he's on deferred. So it becomes an issue because now I can't get rid of those two first charges. So you got to get kind of creative in how you do this. Now, there's some ways you can do it. Some judges will let you do first half pleas and then do all of them together. So the judgments are all on the same day. You got to get kind of creative. I mean, that's for you to kind of look at in the moment, but it's something you have to keep in mind is that when you're doing that, you're taking away someone's ability to get these things cleared. I have a client right now, 5 charges. Looks like there's 2 different attorneys. They did exactly what we're talking about here. They pled them on different days. And so they have 5 charges and only, I believe, 2 are eligible for a non-disclosure.
Now that's because you've got to wait a certain amount of time. You can't have had another conviction during a certain years-long period.
Right. While you're on deferred, you can't pick up any new charges and during that waiting period. So because they pled while they were on deferred, that makes those charges ineligible for this non-disclosure. And that's something you guys kind of keep in mind. Now, the other thing that I've been starting to tell people about, I don't know if anybody knows about it, but this plea and bar. Okay. Prosecutors tell me all the time, they think they're doing me a favor. I have 2 charges. Usually it's like a DWI and a UCW. And they're like, hey, we'll plea and bar the UCW and just plead the DWI. Well, that sounds great, right? Because I'm getting dismissed. I did it. But when I go to get that record clearing, when somebody comes to me and says, hey, I got this case, I was dismissed, and I send it up to the expunction, it's hard for me to find out that it was plea and barred because there's not a lot of paperwork on it. But what ends up happening is they say, hey, you plea and barred, you pled. And if you plead, you've entered a guilty plea. So now there's no way you can get that record cleared. So be careful with the plea and bar. You just want that thing dismissed. Plea and bar is not good. It's an effective guilty plea. You're pleading guilty, and they're going to take that punishment there, and they're going to apply it to this case. If they do that, this case, the case that you plea and barred, you can't get any record clearing on. So again, something to think about. Talked about pretrial diversion a little bit earlier. And again, it never ceases to amaze me how many programs there are out there. There's veterans programs, there's DWI programs, there's all sorts of programs you just got to know about. It takes a little bit of digging, but it's definitely worth it because all the different counties, they have different things. They have different criteria for what they take. But if you know about them, you can always apply for them. If you don't get it, it doesn't really hurt you. But you gotta take that step and apply for it. So again, something to keep in mind. After that pretrial diversion, and we may talk about this a little bit later, but I want to bring it up. You are eligible for that expunction, but you got to take affirmative steps. And this is where I screwed up way early on. I didn't know that. I thought it was just, hey, he did the program, we all high-fived, and then he got his expunction. Not the case. Okay, not a fun conversation to have with your client that, hey, I just forgot to submit the paperwork. All right. So again, got to take those affirmative steps afterwards. Sex crimes and other charges requiring registration. Okay, if you get a sex crime, even if you get deferred on it, no record clearing. Okay, if they get that, you get any sort of sex crime, anything that requires registration, you're not going to be able to get a non-disclosure on that. So again, keep that in mind. Disqualifying criminal history. Okay, so there are charges, and there's this really cool thing online, and you can type it in. It's really easy. Just type in non-disclosure Texas, and the U.S. courts, the Texas courts has this cool thing. It's an overview of the orders of non-disclosure. It has all these things in here. So you got all these different types of charges: murder, cat murder, trafficking of persons, continuing trafficking, on and on and on. Things you got to know about before you're going to be applying for these non-disclosures. You got to know what their criminal history is. It does matter for your eligibility for that non-disclosure. Waiting periods. Okay, so you got to know the waiting periods. So you got different ones for different charges, right? Again, that's all in this thing. So I love it. Okay, but you got to know what you're looking at. So you got to know the charge. Got to know how long that waiting period is. Is it a misdemeanor? Is it a felony? Know what they are. Ineligible offenses, domestic violence. Okay, you get that affirmative finding of domestic violence, not going to get that non-disclosure. Class A, not gonna get that non-disclosure. Now, I know some of you, maybe from criminal law, you may be wondering, what about a Class C family violence? Now, there's some split things. I'm not gonna get into all that because it's a lot bigger subject, but those are eligible for an expunction. And those are the only ones because again, it is domestic violence, but it is a Class C. So you can do an expunction there. But if it's a Class A misdemeanor and you have that domestic violence, that affirmative finding, there's not going to be any relief for record clearing there.
That Class C, you may find yourself in muni court for that, right?
That's correct.
Okay.
Yeah, that's correct. Okay, then know the difference. Guilty, deferred, acquittal, and actual innocence finding. Okay, those are all different. I love in voir dire, I watched this old attorney. He was doing voir dire and he asked people and he kept asking them, and I didn't know why. I saw him do it a few times, but he'd say, if they're not guilty there, and everybody says innocent. And he's like, well, that's not true. No, it's not guilty. It's not guilty, right? And we know the difference because we're lawyers, but that matters, right? Because not guilty and actual innocence are very different things. You got to know the difference between those two things. Know all of these things. Got to know what they mean and what they're going to mean for those record clearing. Okay.
Expunction law. Okay, you'll find most of the things you need to know about expunctions in the Texas Code of Criminal Procedure, Chapter 55. We brought it up earlier in terms of the private right of action. You may find a little bit of this in the Section 411 also, but 55 is really where you need to look if you're doing an expunction. So the first major issue we've got with an expunction is whether you're entitled to it or whether you simply may be eligible for one. Huge difference there. Despite the look of this slide, I think what you'll find is that it's much more common that your client will be eligible for an expunction as opposed to entitled to one. So an acquittal in a trial court, either bench or jury. The distinction that we're making here is that it's actually that court that heard the case that has to make this finding. If you go up on appeal, the rules are a little bit different. So the next one we've got is a pardon. Don't know too many people who have gotten one of those at the state level. And that's something else to keep in mind here. Largely what we're talking about here, these are state remedies, not federal ones. There may be some option for that, but that's probably better served for a different CLE. A post-conviction innocence finding. I mean, that's Innocence Project type stuff. You know, they've got some wild numbers. At the same time, it's pretty extraordinary, and you may not run into one of those during your entire career. A mistaken or void charging instrument can be grounds for your entitlement. It's just procedural. It never should have happened, and so you're entitled to it. The next option we have is a dismissal or a quashing with a pretrial intervention program having been successfully completed. So that's basically an agreement you've got with the court. You satisfied it, they live up to their end of the bargain. Pretty simple. So we switch on to eligibility, and here's where we have our acquittal by the appellate court. It's a wild finding, but there's that important distinction here, and that's why you've got to do your background. You've got to look up the nature of the charges and how they were disposed of. The next way we have for eligibility is expiration of the statute of limitations with no final conviction, which is interesting because there are some charges that don't have statutes of limitation, right?
Yeah.
And so again, you've got to dig down into the law. A cool little secret: if you take one of these cases through DVAP, your clients are pre-screened. So trust but verify is the path that you can take there. But you know, DVAP is just incredible training wheels. If you haven't taken one of their cases, I highly recommend it. They can set you up with draft pleadings, mentor attorneys, Kristen, who you saw the introduction to this, and Kathy Saldana, and everybody else there at DVAP. They will help guide you along the way to help assist some deserving clients in getting this very important relief. Okay, we get into the eligibility timelines. So 5 years for a felony, that goes back to the story that I opened with. You know, my client was stuck with that terrorism charge, may as well have been terroristic threats against a household for 5 years before they even had the ability to apply for an expunction. But on here, we've also got distinctions about limited expunctions versus full expunctions. And Nick can help a little bit about this, but the major difference we're looking at here is that instead of our total Thanos obliteration, the state's still going to hang on to some of these things. And the reason you might want this is you're not offended by the state having access to the records, but to deprive it from the prying eyes of potential employers, family, friends, the value may be there. In terms of the full expunction, you're going to have to wait a lot longer, and you need to dig down on what the actual charges were. I think we've got some examples down here where for some of these felonies, you may be looking at a 10-year, 7-year, 5-year statute of limitation. And so if you haven't done the work, you may apply a little too early and end up with a little bit of egg on your face for not having done it the right way. I don't know if you've got anything to.
Yeah, so I will say with these limited expunctions, that is exactly what always comes up is I want a full expunction, but I want it now, right? And so you can't have that. So we tell them you can get this limited expunction, you can do it after 5 years, but they're going to hold on to the records. It's not a true expunction, right? It's limited. And that's why people do it, is for jobs and stuff like that. Now, one thing to mention with this is you can get the state to certify that they no longer need those records. But as we put here, good luck. Okay. And I'll give you an example of this. We had an attempted murder charge. The guy was like, hey, I want to do an expunction. We applied for it. We said, hey, the state's going to certify. The murderee came to them and was like, that didn't happen. Like what you said there, not real.
I'm alive. Yeah, well,
I'm alive. No one tried to kill me. This is not real. The state would not certify that they didn't need those records. No statute of limitations. So they just said, hey, no, we're going to keep them. So he ended up doing a limited, but that's something you can try to do, but I've not seen it yet.
Okay. The other thing I guess here is with these attempts to seek relief, I think you only get one bite at the apple, right? So if you seek the limited expunction, you don't get to redo it later. If you seek the expunction and don't get it granted, is that a total bar to filing again?
So I'm sorry, I was reading the comments of that. So if you try to do a limited expunction, if it doesn't, you said it doesn't get granted?
Right, either.
Yeah, I don't know. So if it doesn't get granted, if you're not getting them to certify, then you would be eligible for it under the statutory time limit. I have not had one that was not granted, but I know if you do get it granted, there is no way for you to go back and get a full expunction.
All right, so we've got this question here that we may go ahead and knock out now since it's way on topic. I think you all can see it, but I'll read it just in case. So one of our attendees has said they've got a client whose case was dismissed due to evidentiary issues and new information. The new information was that the complaining witness said that the event didn't happen. It was a felony offense. Will the client be eligible for an immediate expunction under Section 55? The indictment dismissed due to mistake, false information, or required to wait for the felony SOL. So I'll answer this first, then I'll let Nick correct me because he's awesome. My thought would be no. That does not sound like a mistake in the charging instrument. That sounds like a mistake of fact and not a procedural defect in the charging instrument.
Yeah, that's what I would say too. This happens a lot where we get, CWs who then say, hey, I lied. That does not give you the ability to just go and get an immediate. They would more than likely, they're going to need to wait if you want the full expunction, the statute of limitations, if this charge has one. If it doesn't, then we'd be looking at a limited expunction and you'd have to wait the time frame.
All right, so I'll click answer live and done.
All right. Okay, so non-disclosure law. All right, Government Code 411, subchapter E1. We tried to list all these. We realized there was way too many of them. So we just wanted to point you in the right direction here.
And you can go to your.
And you can go to your cheat sheet.
handy cheat sheet.
Yes, that's right. All right, so there's no entitlement to be granted for a non-disclosure. All right, you're just entitled to apply. Okay, and they're granted if in the best interests of justice.
A qualifying applicant is entitled to apply.
That's right, qualifying applicant. That is true. That is true. And it's in the best interest of justice. Now, I have looked up this phrase, best interest of justice, on Lexis all last night because I've been ever so curious about this phrase. I could not find a actual definition. Now, I will tell you that what I've found is that judges want to know that it's in the best interest of justice in like you're good for society, that you're doing things for society. And that's what you need to put on for your client. If it becomes contested, if it's something that the state is not going to agree to, then you want to bring people to show that this person is good for society.
And, you know, I've probably cleared hundreds of charges for DVAP clients at this point. And it's extraordinarily rare that the state actually challenges what I put forth. But one of the ones that comes to mind was somebody who was a correctional officer who had been accused of stealing from an arrestee who also may have been non-status in terms of immigration. And so the state challenged us saying that, you know, my client who's in a position of authority allegedly took advantage of somebody who was maybe the most vulnerable in society. And so they put on a defense and a challenge to our sought relief. And that is one of the very few times that I've actually had to go into court to work up one of these record clearing relief motions. It's extraordinarily common that the state will agree to the relief being sought. The judge still has discretion, but you know, when we ultimately got relief in that challenged hearing, you know, the judge gave an admonition and basically said this is your chance to get going straight again. I'm going to allow it, but you recognize that, you know, best interest of justice. We don't want to see you back here again.
Yeah, and same thing. Most of these just get granted without a hearing. I've had one that I can remember that was very contested, and it was because he was actually charged with a sex offense that was registrable. The state pled it all the way down to something that wasn't, and then the state wanted to go back and say like, well, we don't want them to do the non-disclosure because of this, and that became very hotly contested. He brought 5 or 6 witnesses to talk about him. You know, he was not just somebody on the street. He had he was a lawyer, and so we had to do a full workup for that. And same thing, you know, the judge ended up granting it, but it did take a lot to show. We had to show that it was in the best interest of justice there. So just something to keep in mind. Okay, now the other thing that to keep in mind here is where do you file these things? We can talk about them all day, but if I don't get them in the right place, it really doesn't matter, right? So with expunctions, they're ex parte filings, and they're with the criminal district clerk.
I used to have to hand file these things, print out multiple copies of them and walk them in. And at least in Dallas County, they've caught up with the times, mandatory e-filing.
That's right.
And so it's a lot simpler these days.
Yeah, so always in the district clerk. Okay, Class C's, I send them up to the district clerk. Okay, well, you can do them through the municipal court. But again, I wouldn't do that. It just becomes more of a rigmarole to kind of do it. So I just file everything through the district court. It just makes everything more streamlined, and you do it that way.
When you're doing that for an expunction, I think you need to list it as an original proceeding. So that's part of the context of this being ex parte. It carries a new cause number, and in Dallas, it'll start with an X, probably for expunction.
I just put that together.
Yeah, but that's something important to know. And the other cool thing about that is if you're doing these expunctions, because it's ex parte and original proceeding, you can file expunctions for multiple charges at the same time.
Right.
I don't know that we made a slide about it, but it's a huge distinction that'll become more clear as we talk about the filing of these non-disclosures.
Right. That's a really good point. We did forget to put that in the slides. So non-disclosures, this is going to be where the court where the offense was adjudicated. So this is actually going to be filed into the criminal case. So that's why you're going to go back to the court where this charge was actually adjudicated. And it's going to be filed with the clerk of the applicable county or district court, or clerk, excuse me. Again, because if it's in the original court, if it's a misdemeanor, it's going to be going to the county clerk. If it's a felony, then you'll be going to the district clerk. Okay, so those are the things to keep in mind with where to file.
Yeah, and for Dallas County, when you're doing one of those, my first cheat sheet for those non-disclosures is go to DallasCountyCourtRecords.com. The first entry is going to be the district clerk's website. You click on that link, put in your client's name and first name, last name, which brings me to another point about your client's names, which we haven't put in the slides. And on it, Dallas County has the funkiest codes for their courts. It's, maybe A through Z, and then they start getting to double letters. And then you've got to click on another button, which translates those to the current court settings. I've had some where maybe the court numbers had changed between the time that the charges were brought and the time that we were seeking relief. And so you've kind of got to do a little bit of matching there. But in terms of the names, I always use the name on my petition that was in the charging instrument, but sometimes that doesn't necessarily match the name that was on my client's driver's license or social security card. And so early in the petition, when I'm identifying the parties, I make sure to put the name in the charging instrument and then a parenthetical with, AKA, also known as, and every iteration of their name that I can see. Some of the names that you may want to include in there are the things you find on the Dallas County court records. I've had clients who've been charged dozens of things that may have been eligible. And so you want to list every single instance and variation of their name, both in your petition and in your proposed order, because you'd hate to go through all this work and get the name wrong, or get the name right, which prohibits your client from getting the relief that they're seeking so badly.
That's right. Is worth noting, Dallas County for the criminal side has switched over to a new system. So the Forvis that we all know has gone now. So it's a little bit more difficult. You could do your own CLE on that new thing, but just worth noting, just so you guys know that is not being updated anymore, but it is still active, just so you know.
Okay, DVAP. Kristen gave us a great introduction to it. I don't know that she mentioned the mailing list. Whitney over at DVAP sends out something every month. I think you can ask to get added to that list, and they make a list of people who take pro bono cases, and they also just provide a list of a bunch of ones for which their clients seeking assistance from attorneys willing to do so for free. The mentor attorneys we talked about, the templates we talked about. A lot of people refer to this pro bono work as billable hours for the soul. It's the real deal. It's worth doing. If you don't have a full caseload, it's a great place to cut your teeth. And I can tell you, a lot of the pro bono clients that I've worked for have been my biggest cheerleaders throughout the course of my career. It's the ability to go help somebody who everybody else had said no to, or who thought they couldn't afford help. And so doing that, it's good for you. It's good for them. It's absolutely worth doing. Okay. The other benefits of doing an expunction or non-disclosure through DVAP and Legal Aid in Northwest Texas is that your client is probably going to receive a fee waiver. So something that's different for most of my record clearing petitions than maybe for Nick's is I attach an affidavit of inability to pay costs to each one, which is a 2-page form that's filled out by my client that talks about who they are, what assets they own, what income they get, and what debts they have. In all the record clearing petitions that I've put forth, I don't think I've ever had the court challenge me on one of these. And you don't have to show that you're broke. You just have to show that you're, it may be less than 150% or 200% of the poverty level. But it's extraordinarily helpful to be able to get these fees waived, because I think it's probably approaches $300 to get one of these filed on the front end, but you may run into significant costs on the back end with something that we mentioned earlier. And we'll talk about that in just a second. So we've got this affidavit of inability to pay costs. The second thing that's submitted with one of these DVAT petitions is an IOLTA certificate from the attorney. And it basically says, I, Adrian Bauer, am representing, John Doe, who's been pre-screened by Legal Aid of Northwest Texas to be, effectively indigent and deserving of pro bono legal services, which we're providing through Legal Aid of Northwest Texas, which is, I think, it's affiliated with the IOLTA program. So the interest on lawyers trust account that actually is accrued and y'all have never seen because it gets remitted to the state, goes into a fund. And I think they dole a little bit out to some of these legal aid organizations to help facilitate this relief for deserving people. I said I was going to talk about something. Oh, the huge costs that we're avoiding. So attached to my petitions and orders, it's important to put the list of people you want to be made, people and entities that you want to be made aware of the record clearing instrument. And in the body of my petition, I may include 5 or 9 different entities, the arresting agency, the jail where they're housed, the DPS, maybe the FBI, a couple biggies like that. But the other thing that I do is I slap an Exhibit A onto my petitions and orders that probably lists several dozen different people who purchase criminal record information from the Dallas County or other counties. And the reason that's important is because all these people, whether it's a LexisNexis type entity that just wants comprehensive background records on people, or whether it's a criminal defense attorney who pays for access to arrest records so they can, hopefully in compliance with ethical rules, send out mailers to arrestees to say, hey, we could represent you. So I put a list of all those people on there. And for my clients, it doesn't make a difference in cost because they've gotten fee waivers. For Nick's clients, it's a little bit of a different story, and he can share something about that.
That is no joke. We also used to have those on there. Before we used to get away with it. No one really asked us to pay for it. And then one day they really asked me to start paying for it. And so submitted an expunction. I think the filing fee was like $360. And that was what I told the client was going to be. It was around there. And they said, well, you have this Exhibit A and I think it was $25 an entity. So they said, all right, well, so your total fees are going to be about $1,000. And I was like, well, oh, okay. Client obviously didn't want to pay that. So we've had to remove that. So, doing these through here, you actually are able to notify a lot more people for cheap because the court isn't having you pay for that.
Yeah. And there are a few ways to think about this. The types of stories I hear from my clients about why they so desperately need this relief, $1,000 is probably worth paying. To get their life back moving, to get a job, even at minimum wage, that's, 2 weeks and you may be back in it. Yeah. But it's cost prohibitive. And if, your criminal defense practice, I suspect with a lot of these, you're flat feeing the work, which is good business if you can get it. But when you don't recognize the math, if you say flat fee inclusive of costs, you may be eating $1,000 bill like Nick over here.
Yep, that happened.
All right, our takeaways.
All right, so these are the big takeaways. These are the things, if you take nothing else away, if you've been, if you're doing something else, I get it, Zoom, these are the things you got to take away, okay? Plead your client's case right, okay? Irreversible consequences can result. So we talked about that plea and bar. We talked about playing them on different days. Make sure you understand all that stuff. Make sure you know what you're doing there. Confirm that eligibility. I told you where to find this thing. You can find this thing and you can confirm their eligibility or ineligibility.
Yeah. I had a fun one of those recently. I had a client who had been put on unsupervised probation.
Oh, yeah.
And so the language of the statute says you're only eligible if you weren't on supervised probation. Something to to recognize, as counterintuitive as it seems, unsupervised probation is supervision for purposes of the statute. So, read your list, check it twice.
Yep. Okay, we'll look out for that 42A. File with that appropriate clerk. Okay. Again, something that took me forever to figure out was where to file these things. I used to have to file it, get returned, file it, get returned. It just ends up, driving you nuts. But if you know where to file it, that's the main thing here. We've told you where to do that. Notice DA's office and district clerk. Okay, so you got to let the DA's office know when you're filing these things. That's paramount, and the district clerk as well. They're going to have records. You want to make sure that you're noticing them. So both of those people are getting rid of the records with this expunction.
And with that, you can, in your e-filing system, you can put them as an additional, third-party contact.
Right.
Most of these counties, I think, will list a specialized email address for expunctions. It's not going to be tied to a natural human. It's just a designated inbox for that. Right. Make sure you put it in there. I've had it happen, sometimes even when I have included that, where these things just get missed by the DA's office. In Dallas, I think it's the appellate division that handles the expunctions. It's good to check in with them, but play nice with the other kids in the sandbox. If you look at chapter 55 and 411, you'll see some kind of dates at which you're entitled to a hearing, or by which they've got to have this completed. Don't be a jerk to the people who you need help from getting the relief for your clients. I had one that happened, I don't know, a year and a half ago, where the DA assigned to my case got it right before she went on maternity leave. And it's a tough conversation to have with your client, when usually these things can take 3 to 5 months. But basically we were stuck in a position where this attorney had to deliver her baby before our client was allowed able to get the relief that we wanted. But be friendly, because practically speaking, the way this works, and Nick mentioned it, I think I did too. When I draft up one of these petitions for a record clearing relief, I usually have to do about 5 minutes of work after I submit my petition. The reality is, the petition goes in, the DA's office sees it, and in 99% of the cases, they say, we're not opposed. We will file a general admission. We will take it to the judge. You don't need to come to court, and I don't.
Do not either.
It's pretty simple. So with the information that DVAP gives me on these clients, I'm able to draft up the documents that I plan to file almost completely. One of the things that I've seen missing sometimes from the DVAP packets is the client's address at the time of the arrest. And so I usually have to source that from the client, but DVAP will send me over the packet of all the information on the client. I'll draft the petition, the order, the IOLTA certificate. I bring in the client to my office, and we fill out their affidavit of inability to pay together. On the phone call leading up to that meeting, I ask them about past addresses. Sometimes they have them, sometimes they don't get them. It'll be okay. But the DA's office will sometimes help you fill in that additional information. Yeah. But it is my common practice that the day I meet with my client for the first time is the day I submit their materials. And after that, it's a waiting game for the general admission, maybe a friendly phone call to the DA's office to seek it out, see where we stand on it. And then the next communication that I usually get is notice that the judge has signed an order. But after that, the story's not over. On both of these record clearing relief options, I think there's a 30-day waiting period to make sure that they're actually giving this record clearing relief to the right people, somebody that deserves it, not accidentally clearing the record of a murderer or rapist who wasn't entitled to that kind of relief. So when you get that final order, 30+ days after it's been signed by the judge, it'll have a stamp on it from the clerk that is a certificate of finality.
That's right. That's right. And that's what you got to wait for. Once you get that, then you've got it. And then it goes to the, checking again to make sure that you've gotten everything. So, I mean, that's scouring the internet, you can still find traces of it from here and there. One thing I will tell you is we found out recently is, some of these websites, they're just pulling information from other sources. So those places get notified, but where you're seeing it online, it takes them time to batch it. And once they batch it, it will go away. Usually that's about 90 days.
Yep. And so sometimes the way search engines work, they will be able to pull a record of it, but it'll go to an expired page
Right.
even after they've done it. So it's good after you've gotten some of this relief to scour the internet periodically to make sure that nothing's popped up, and have a letter drafted up to send to those people with a copy of the order that says you need to take this down. And maybe check back up on them again in case you want to do a Commerce Code 109 or what is it, 411-085, to see if you can turn the unfortunate arrest into a money-making opportunity for your client.
That's absolutely right. I think that's it. So
Yeah, we may be at the end. Does anybody else have any questions that we might be able to field? Ooh,
yeah, let's see. The petition.
do you include the magistrate cause number in the petition proposed order on an expunction or non-disclosure? A magistrate case number. So is that for a muni court thing? Is that?
Well, so because I would need a little bit more information, because I think what you're asking is if they have seen them, if they get a magistrate case number, have they been, because you're asking for an expunction or a non-disclosure, so did they plea out on it or did they not? I mean, we would need more information to answer that question.
But zooming out a little bit, for a expunction petition, I do not put a cause number in the header. For a non-disclosure petition, I do put the cause number in there from the original case.
Right.
There are two other things on a lot of my petitions. So there's sometimes the arresting agency will give a unique number to a case, and I don't always have access to that. I just leave a blank next to it in my petition. A lot of times the DA will fill it in for me.
Yep, the court gives a number too, the TRN number, and I leave that blank and it always gets filled in by the time it gets back to me.
Yeah.
So yeah, definitely something there. Any other questions? I'm sorry, we can't answer your question, anonymous attendee.
Well, I think Maricela had something that she was going to share, but if another question comes up during that time, we'll be happy to field it.
Yeah.
Thank you, Adrian and Nick, for that great presentation. Just a couple of housekeeping items. A copy of the PowerPoint presentation will be provided via email, and that'll be coming from Zoom. So we'll look out for the Zoom link with all the shared documents. As far as CLE credit, we ask that you report your CLE credit to your State Bar of Texas profile. And Adrian and Nick were so kind and included it in their slides. So I'll just go ahead and read that number for everyone. It's 174-202-738. Again, that is 174-202-738. And it looks like we did have one more question for you both. That's asking any recommendations on where to acquire a comprehensive criminal history for the client.
So there are a few things I can tell you. When I do a DVAP case, they send me the criminal history. I also look in Dallas County court records, and I think you can probably get one from DPS. I've got Lexis. I used to have Westlaw. You can do their people map searches there. I don't know if you've got a different resource that you use a lot.
So I usually use a private investigator because he runs a background check and does all that. And he kind of does that all for me. And then I get a full view to see if I can see it anywhere at all. Because if he pulls it, then I know that it's around at least somewhere.
Great.
Anybody
question.
else?
Okay, it looks like we do not have any additional questions. But if you do have any questions, feel free to email me and I can forward them to Adrian and Nick. And again, thank you all for attending today's presentation. We hope that you learned a lot from the material that was presented today, and we wish you a good rest of your afternoon.
Thank you all.
Thanks, everyone.
Thank you.